Hi, this is Estates and Trusts, online module 6A. We're looking at various changes that can take place after an estate plan is in place. And this module only focuses on a couple of them, but just for an overview, there can be changes in personal status, like marriages, divorce, death, childbirth. The decedent might have handed out property ahead of time. Some of the beneficiaries might not want the property. They might file disclaimers. Sometimes the beneficiaries don't want the decedent, and sometimes property has disappeared. So any number of things, and what we'll be looking at here is the effects of some of these changes. Okay, specifically in this module, we're looking at advancements and divorce. After this module, you should be able to explain the concept of an advancement or satisfaction. You should be able to identify situations where we might find that there has been an advancement. If there has, you should be able to use the hodgepodge to determine the disposition of the estate. And you should be able to explain the effect of a divorce on an existing estate plan, focusing on each different kind of transfer. Okay, so sometimes we're talking about changes to an estate plan that operate automatically when something changes in the decedent's life. So for example, when people get divorced, there's a statute that automatically revokes provisions in favor of the ex-spouse. So do we want a statute that also revokes insurance, that revokes retirement benefits? What about joint tenancies? What should the statute do in these circumstances? Moreover, should the rule be the same for wills as for non-probate transfers? If you didn't do it already, please read the law review excerpts at the beginning of the section or chapter, especially the one by Longbine on pages 225 to 227. And then the question that I always sort of think about is, would a newly divorced person remember to go in and change all of the life insurance beneficiaries, to change the will if there's a will, to go to the employer and change the beneficiaries on whatever retirement plans are in place? Uniform Trust Code, now there's a Uniform Probate Code that we've been working with, but there's also a Uniform Trust Code, says that any rules for construction of wills should also apply to a trust, but that still doesn't answer my question about the life insurance. Okay, let's look at advancements. Sometimes a donor makes a big gift and intends that to be an early inheritance. And if it is intended to be an early inheritance, we call it an advancement. The problem is, once the person dies, we know that the gift has happened and we know there's an estate. How do we know if that was an advancement? Sometimes it's inappropriate to have a presumption that there was. For example, if a parent makes a big gift to one child but not to the others, in a lot of jurisdictions we presume that that was an advancement. Here's the Minnesota Probate Code, which is the same as the Uniform Probate Code. If an individual dies intestate as to all or a portion of an estate, then property the decedent gave during the decedent's lifetime to an individual who at decedent's death is an heir. So property that you gave to somebody who turns out to be your heir, and that usually means a relative, right? We've seen how that works. That's treated as an advancement against the heir's estate, the heir's intestate share, only if there was a writing, right? Notice that either the decedent had to declare it in writing or the heir could acknowledge it in writing back at the time of the gift. So only if there's a writing. Okay, in other words, what's the presumption? Presumption is not an advancement unless there was a writing. Okay, so here's the example from your casebook. Casey dies, leaving 3 kids and an estate of $20,000. Now, Casey already gave Lucy $1,000. This is Lucy right here. Right? Okay, so Lucy's not a son. Okay, but dies with an estate of $20,000. And we've decided this was an advancement. So now what do? Well, we imagine a hodgepodge. Now, this is mostly a legal term. It applies for a particular context in the income tax, and also here. I don't hear it ever used for anything else, but you can picture a big pot, and we're going to put all of those advancements and the estate into the pot in our minds, only in our minds. No real pot here. Okay, no real cauldron either. Okay, so there's a total now of $21,000, right? The advancement and the estate. And that works out pretty nicely because we've got 3 beneficiaries, so we know each one should get $7,000. But we've only got 20. Oh, but wait, Lucy already got $1,000. So Lucy now gets $6,000 and the others get $7,000. All right, isn't that slick? Works out really nice when the numbers are cooked so that they perfectly match. Doesn't always work out that way. Sometimes the advancement was too big, and so the beneficiary of the advancement has already gotten more than her third. Now, we don't use this rule to take anything away from anybody. It's just to tell us whether that person gets anything more. There's a similar concept that applies for wills, and we call it satisfaction. So, for example, if a parent makes a will and it divides the estate among the kids, and then the parent pays one child a large sum, that might be a satisfaction of the bequest. We might be paying it out early. Let's look at a case. This is YIVO Institute for Jewish Research versus Zaleski. Now, Dr. Jan Karski. Jan Karski was a Polish Catholic, and he had a role in bringing the attention of what was going on to the West. But that was a long time before this case. He pledged to establish an endowment, and the endowment fund would provide an award for authors whose works focused on Jewish-Polish contributions to culture and science. Okay, he promised he'd establish an endowment. Then he executed a will that would leave $100,000 in stock to the Institute. And after executing the will, he actually gave them $100,000 in stock. So he made good on his pledge. He followed through, and then he died. Okay, so our question is, when he made that gift, was that the end of it? Right? He promised to make an endowment, made the endowment, but there's this provision in his will. Is that supposed to make another gift, or is he done? Was the bequest satisfied with the lifetime gifts? That's how we would say it. Or did he intend to make a gift and a bequest? Well, do we have a presumption? Do we have a Maryland statute? We have some general rules, and the general rule that the court cites is that if the testator was the parent of the legatee, then the gift is presumed to be in satisfaction. Well, that doesn't help us. If the testator was not the parent, it's presumed that the subsequent gift did not, and here's some nice terminology, did not adeem the legacy by satisfaction. To adeem kind of means to nullify, and we'll see this again with when the property in the estate has changed. So presumptions can be rebutted. Hang on, let me go back to that. It's presumed not to adeem the legacy. In other words, the presumption is that it was not an advance, it was not a satisfaction, that it was intended to make a gift and a bequest. Okay. So we saw before that under a statute, an advancement against an intestate estate, an intestate share, has to be in writing. Should that writing requirement apply here to the satisfaction of a will bequest issue? Well, the restatement says it should. The restatement is actually quoted in the case. An inter vivos gift made by the testator to a devizee or a member of devizee's family adeems the devise by satisfaction if the testator indicated in writing or devizee acknowledged in writing that the gift was to operate, very much like the Uniform Probate Code. And of course the Institute says that ought to be it. You know, if you didn't have a writing, then it's not in satisfaction of the devise. But the restatement is just advice. It describes the common law and it sets forth best practices, but it is not itself a statute. And in fact, Maryland had not adopted the restatement or the Uniform Probate Code. And the court says we need to know his intent. And so we're going to focus on the purpose of the bequest. What purpose? Okay, well, court says it was to fulfill or otherwise provide security for the commitment that he made to YIVO. And the gifts had the same purpose, right? So we have the promise of the endowment, we've got a gift satisfying that, we've got a bequest satisfying that, same purpose, and they were gifts of the same kind of property, right? So we might not feel the same way if he had promised a building and then given them artwork, for example. But with the same purpose and the same kind of property, that gives the Maryland court enough to say, oh, okay, we're going to presume this was satisfaction, that we're going to presume he did not intend to make two big $100,000 bestowals upon the institute. Okay, here's just a little bit more about Jan Karski. Take me out of this. You can go to the PowerPoint and go to this website if you're interested. Kind of a hero of a guy. Okay, I'm going to stop this one here, I think, and then we'll go on. But, you know, first of all, before we go, wouldn't it have been easier to have a statute that provided a presumption? Right? The Maryland court had to go to a lot of trouble to arrive at its presumption that this was that this was in satisfaction of the bequest. This is why I like statutes so much. Okay, and thought for the day, if Dr. Karski really had wanted to make two transfers, how would you have advised him to make sure that the Institute got to keep both transfers? Okay, we'll stop here, and I'm just splitting this so the videos won't be too long, so come right back.